Hey people, what's up? Are we good now? Okay. All right, we'll wait for everybody to trickle in. How we doing? There we go. Sorry about that. It's the first time I ever saw the. It's the first time I ever actually saw my notification. What's up, people? Oh, we got a case. We got a good one today, people. That viewer count. I don't know what's going on with my viewer count either, because that ain't right. Let's wait for everyone to trickle in. Ah, we like the new sound, the subscription sound. We like it, we like it, we like it. Oh, there we go. There we go. Here we go. We are racking and rolling. Let's roll. All right. Before we get into the main event, okay, it is literally forget about thruple. Even forget about a quadruple. I think this is a new form of ruple called a PolyRouple. And extra toes, and of course, a custody battle. So let's start with a little Middleton, and then we will hop right into the main event. Let's roll. Mr. Middleton, help us out, get us warm, and then the PolyRouple.
Smith, I don't think you speak Latin. I barely do. But in vino veritas means there's truth in wine. And what it basically means is sometimes when people are drunk, the truth comes out. And you were intoxicated when you were here yesterday. And I'm not saying you hadn't been truthful otherwise, but the truth came out. You essentially drink all day, every day. As I said yesterday, I've known you since you were in 8th grade. You were friends of my son. And you're in rough shape. It's not a good thing, obviously, to show up drunk for court. You didn't do it to be contemptuous. You did it because you have a terrible substance abuse issue. You got another drunk driving pending in Cass County. Your blood alcohol was very high.
Tommy, I want to thank Tommy for giving me that sob sit yesterday. I forgot to put it on my video. Thank you, Tommy. Thank you, My Crazy Life. Thank you, Monica, for all the help. Thank you, Miss Rose, for always helping me out. She dropped a video into my inbox, and that I'll be playing in one of my videos. If you haven't checked out any of my videos, go check them out. I have new playlists. I have everything rocking and rolling. So now that we're a little warmed up, we are gonna. I see polyamorous. That's the technical term, Tommy. But PolyRouple sounds so much more salacious for LawTube. So let's rock and roll, people. Let's get into this PolyRouple. So this is gonna be into 3 parts. Part 1, then I went to part 2 and part 3. All right, part 3 I think is still going on. I'm gonna be checking it. But let's roll into part 1. This is out of DeKalb County. Let's go.
Video on him, but he does know I have to have video for it to take. Okay, thank you. So, Mr. King, we're gonna log him off or place him in waiting. Probably log him off.
Yes, Your Honor, because it'll probably be later in the afternoon that we get to him.
Okay. All right. So, Mr. King, we're gonna go ahead and ask you to log off.
Thank you. Okay.
Mm-hmm. All right, and then so we're invoking. Looks like we have Maynard Napier. So how do they? How does Napier fit? Is she court reporter?
Yes, she's a court reporter.
Got it. With regard to the court reporter, what is the position of the attorneys on the takedown?
We have agreed. Sorry.
You both agreed, so you'll both have access to the court reporter, the transcript. All right, thank you. All right, so any other preliminary matters? Thank you. We're going to begin with openings. In your openings, please make sure in the beginning or in the end that you specifically tell me what your prayer for relief is. I write those things down so I can make sure we check them off in the order. So I like to do it. I know some people say, well, I'll do it in the closing, but it helps me consider evidence as we're proceeding. If you let me know what the prayer for relief is as we go. Okay, you may proceed.
Can you all hear me? Just making sure.
Yes. Mm-hmm.
Good morning,
so
Your
Ms.
Honor.
Alex, okay.
Go ahead.
So you're Miss Kritz. Is it Kritz or Miss Kritz? I'm sorry.
It's Kreitz.
Kreitz. I got it all completely wrong. It's Kreitz. Is you and Miss Alexander are going to split the case, or will she be doing it?
We're going to split it.
Okay. All right. Then you may proceed, Miss Alexander.
Thank you, Your Honor. Good morning, and may it please the court. My name is Diamond Alexander, and I, along with my co-counsel, Nicole Kreitz, have the privilege of representing the plaintiff, Mr. Adrian Maynard, in this matter. The matter before you today is a modification of custody and a contempt action. The parties here too were previously married and divorced by decree in 2019. They are parents to a beautiful 6-year-old daughter, and in the divorce decree, mother was awarded primary custody of the party's child and father was awarded parenting time. Since the divorce, mother has established a new polyamorous relationship with one person and several other women. That is not a problem in and of itself, but the dysfunction in mother's household certainly is. Since the entry of the final judgment, however, mother has woefully failed to involve father in the minor child's life. The evidence presented today by our side will show several different things. Mother has concealed information regarding the minor child's welfare from father. Mother has blocked father's access to records, medical records, school records. Mother has on several occasions denied father his parenting time with the minor child and interfered with the same. Mother has allowed her romantic partner to usurp father's role and insist that the minor child call her partner dad. Mother has also allowed the romantic partner to implement rules that are directly contrary to the best interests of the child, including forbidding the child from wearing socks, clearly in retribution after father expressed concerns regarding the minor child's frequent foot issues. Father's home is loving and supportive, and mother's home is dismissive and chaotic with frequent housemates and romantic partners who come and go, insofar as much as this child has reported to her father that she's been misplaced. As a result of all of what I have mentioned, father was forced to file the instant action to not only hold mother in contempt for maliciously excluding father from information regarding the welfare of the minor child, repeatedly interfering with father's visitation with the child, but also to reevaluate and modify custody for the sake of the child's best interests. In a modification of custody action, the court will need to find that there has been a material change in circumstances that affect the welfare of the minor child involved. Opposing counsel is going to tell the court today that nothing has changed and that the situation between the party involving the minor child is status quo. Therefore, the court cannot change custody. This is incorrect, and our evidence will show that. Not only has the co-parenting relationship between the parties degraded to the point of materially affecting the welfare of the minor child, but there's also ample case law in point which holds that failure to provide a parent access to a child constitutes a material change in circumstances such that a modification of custody is permissible.
We're going to hear the whole
More
entire
examples
case.
will be given in closing arguments, but take, for example, Jones versus Kimes, decided by the appellate court in 2007, which held that repeated denial of visitation constituted a material change in circumstance and supported a ruling changing.
Okay, so I see a lot of questions in the comments. We're live, so we can do this. It is Ariel King is the polyamorous mom who's having people come and go. Dad is, I am going to put dad bigger for you guys. In the T is in the top left. We are going to blow him up. Bear with me. Let's get as much as we can. We're going to go. This is dad. There we go. So now we have the entire frame of people, the doctors, the therapists, the judge, everybody. Here we go.
Custody. The court will hear more case law in point, but the evidence will show the same. It will further show that mother has, in fact, repeatedly denied father his visitation, interfered with father's ability to execute his visitation and contact his child. She has interfered with his ability to access his child's records so that he can be in the know about what is going on with her on a day-to-day basis. Once the court finds that there has in fact been a material change in circumstances, the court must then consider the best interest of the child. The court will hear testimony that she believes it is in the minor child's best interest to reside primarily with our client, the father. And in the conclusion of the evidence, this court will have everything it needs to answer our prayers for relief. Hold
I'm
mother.
sorry, can you give me the child's age again, please?
She is 6, Your Honor.
Oh, okay, all right, thank you.
At the conclusion of the evidence, the court will have everything it needs to answer our prayer for relief and hold mother in contempt for her repeated violations of the party's parenting plan, and to award our client, Mr. Adrian Manor, and the father of the 6-year-old child in this matter, primary physical custody of the party's minor child with visitation to mother, and award child support cooperation with the same. Thank you, Your Honor.
All right, thank you. Ms. Ferre.
Yes, Your Honor. Good morning. May it court. This case is not about a material change. I think once Your Honor hears from the witnesses, once Your Honor hears from the parties, the guardian, and sees the evidence, it'll be clear that Mr. Maynard just wants a second chance. He wants a second bite of the apple. Just to provide a little bit more details, the parties were divorced August 28th of 2019, before Your Honor. Your Honor is actually the one that signed the divorce decree. And I will point out to the court that it was not a trial. The parties actually entered into a settlement agreement. There was a consent parenting plan ordered signed by both parties. There was a settlement agreement signed by both parties. The child support addendum was executed and signed by both parties. What Your Honor will learn and hear today is that the allegations that are mere allegations, but nevertheless, the allegations and the complaints that father presents to the court today existed prior, well prior to the divorce. Despite that fact, father still agreed for mom to have primary physical custody of Ivy. She is 6 years old. He has agreed for her to have joint legal custody, shared decision.
Sorry, I apologize. What was the name again? Can you spell that for me, please?
Yes, Your Honor, excuse me. It's Ivy, and it's spelled Aievy. So Ivy just turned 6 years old in February. So essentially, you will learn that father agreed for mom to be tie breaking because he thought it was in the best interest of the minor child for her to have tie breaking on education, non-emergency healthcare, extracurricular activities, and religious upbringing. Additionally, the parenting time that was agreed upon by the parties is that dad currently exercises every other weekend, Friday at 9:30 p.m. to Sunday, 9:30 p.m. The court will learn and hear that dad resides 116 miles away in Columbus, Georgia. Mom resides in DeKalb County in Stone Mountain, to be specific. At the time that the divorce decree was entered—
I'm sorry, give me that address for dad again, please.
Dad resides at 2525 Norris, Norris Road, Unit 38, Columbus, Georgia, 31907.
31907. All right, thank you. Make a team.
Mom resides in Stone Mountain, Georgia, 1505 Field.
I really just need the zip codes. That's all.
Oh, okay. 30088.
All right, thank you.
And essentially, Your Honor will learn that even at the time of the divorce, the parties lived in those respective places. That is why the parenting time was set the way that it was. Also, Your Honor will learn that the exchange location in the consent parenting plan has the parties exchanging in Noonan, Georgia. My client agreed to drive an hour to meet dad halfway in Noonan, Georgia, and dad also drives up about an hour to meet an exchange in Noonan, Georgia. The reason I mention that is because the evidence will show that what the allegations dad makes are allegations that he made even before the divorce was finalized. Your Honor will learn that Mr. Maynard has played games with providing his address. Your Honor will see text messages prior to the entry of the divorce where he refused to provide his address. But Your Honor will also see text message exchanges where my client, Ms. King, has provided her address. Your Honor will also learn that there is nothing that Ms. King has done personally to inhibit that from accessing the minor child's school records. Your Honor will learn that he has been able to contact the schools. He's been able to communicate with the schools. He's been able to even take the minor child to doctor appointments and retrieve records for her. That has not been any impediment by my client. Your Honor will also learn that at the time that Dad filed this action, I find it interesting that it was filed exactly almost 2 years after the entry of the divorce decree. It was filed October 13th, 2021, 2 years and some change after the divorce decree was entered. Thereafter, you'll see that many of the evidence that Dad presents here today is all evidence that he gathered when building this case during the pendency of this action. In other words, the evidence that he presents will be all evidence after he filed this action. Your Honor will learn that Dad records the minor child, Dad interrogates the minor child, Dad questions the minor child. So much so that the guardian had to file a motion in this case asking that the child undergo a forensic interview with Dr. Levy, so that way we could discern truth from what the minor child has been coached. So we would ask the court to certainly take that into consideration when weighing the evidence and testimony of the parties. The motion for the guardian ad litem, the record shows it was filed almost 10 months by Dad after he commenced this action. It was filed in July of 2022. We opposed that motion. Your Honor granted the request and made Dad solely responsible for the expenses. So Ms. White's services has been fully funded by Mr. Maynard. But the reason I raise that is because, Your Honor, I think the evidence will show and support the fact that Dad has just been going on a fishing expedition to find some reason to get a change of custody in this matter. Your Honor will learn that even after the guardian's investigation, that the guardian was pressed to find a material change in circumstances. Your Honor will also learn that throughout the duration of this proceeding, that Dad has essentially attempted to build a case for a change of custody that does not exist. The case law that I will provide and go into more detail in closing is going to be the case of Burnham versus Burnham. It's Burnham. It is a 2019 decision by the Court of Appeals. It makes it very clear that in these change of custody cases, it's a two-part test. The first part being, there must be a finding that there's been a material change. And until there's a finding, we cannot get to what's in the minor child's best interest. So once the court makes the finding of a material change in condition that affects the welfare of the child, then at that point, the court then must assess what's in the child's best interest. Also, I'll present to the court later the case of Popes versus Popes. That's P-O-A-P-S versus Popes. It's a 2019 decision, still good law by the Court of Appeals. It stands for the proposition that ongoing parental discord.
And I'm just telling you guys now, the case gets juicy. We actually get to see the extra toe. I kid you not. Let's roll. And again, we are joining forces back to back. Credence and Bishop, time served first. Credence and Bishop followed up. The power couple has started. Actually, that's a throuple on its own.
Is not that existed prior to the entry of the divorce is not a basis for a change of custody. Also, the decision of Todd versus Todd, that is the decision of Todd versus Todd. It is a 2010 decision. It's a Supreme Court decision, still good law, and I'll be presenting that case to the court later. And it provides that there needs to be more than, in that case, living with a boyfriend to a change and award of custody. And speaking of what this case really is about, Your Honor, is not only Dad getting a second chance or a second bite of the apple, but it's Dad raising his concern or issue with Mom being a polyamorous, or what we call a polyamorous relationship. And you will hear from Mom's partner this afternoon, and also you will learn more about that history. Specifically, what Your Honor will learn is that Mr. Maynard, the petitioner in this case, dad, is the one that introduced mom to a polyamorous relationship and lifestyle. Your Honor will also learn that the parties separated at the time that mom was pregnant with Ivy, far beyond the divorce being granted. Essentially, Your Honor will also hear
I'm sorry, say that again?
what Your Honor will learn, excuse me, I'm a little under the weather. What Your Honor will learn
Under
is
the
that
weather.
prior to the divorce being finalized and entered on August 28th of 2019, years prior, the parties had already been separated at the time that mom was pregnant with Ivy. So the parties had separated long
Oh, no, it's a
before
toe.
the divorce was filed.
It is a toe.
Also, Your Honor will learn that even during that separation, Mr. Maynard is the one that introduced Ms. King to a polyamorous lifestyle and relationship. That is what Your Honor will hear and learn. Your Honor will also hear and learn prior to the entry of the divorce decree, you'll see through text message exchanges that the parties communicated about that. So for now dad to complain because mom is not purely heterosexual, is simply just him smearing Miss King's name and trying to degrade her and place judgment on her, when essentially that has never been an issue. It's always been her relationship status, even prior to the entry of the divorce decree. So that's what this case is really about. So Your Honor will hear testimony and see evidence in support of that. As it relates to the minor child, Your Honor will.
So let me just back up, make sure I understand your position is that, because I thought you just introduced Miss King's husband.
Heineken.
Yes, that's her partner. Yes.
Not husband or partner?
Partner.
Which partner?
Okay, so the
Mr.
King, how does she get the King last name?
She changed her name. She changed her name, Judge.
She changed her name to King, although she's not married to King.
Correct.
So her name is officially King.
Thank you, Laura.
Yes.
Okay, I
Yes.
just want to make sure.
Yes.
Okay, so Mr. King is one of her partners, but she is not married to him.
Correct.
Okay, all right, thank you.
And excuse me, Your Honor will also learn that this was a discussion prior to the parties finalizing the divorce. And despite that, dad still consented and agreed for mom to have primary physical custody. As it relates to Ivy, Your Honor will learn that Ivy is a bright kid. She is 6 years old. She is in kindergarten, and she actually is she takes first grade classes because she is testing on a gifted level, even beyond her age. So Your Honor will learn that while Ivy has been in mom's primary physical custody, she has been excelling. She is bright. She has been doing phenomenal in school. And we would ask that the court not change custody to disrupt that. All in all, in summary, Your Honor will see from the evidence that there has been no material change in condition and that Ivy should remain in the primary physical custody of mom. What we will be asking the court to do is to deny any change of custody. And we will be asking the court to award Ms. King attorney's fees pursuant to OCGA 1993, subsection G, which is applicable in this matter. And we will be asking for at least, and I say at least because I haven't computed the time to today, but at least $14,478.55 in attorney's fees. Thank you.
Okay, let me figure out this first issue dealing with the change of circumstances. I'm gonna make sure I can kind of get this narrowed.
Definitely.
Ms. Alexander, in a summary, what is the change of circumstances that you're presenting?
Your Honor, we're presenting that first and foremost, the environment in Ms. King's home has changed since the entry of the parenting plan. There have been multiple partners in Ms. King's life who have come and gone. So it has changed multiple times since the entry of the parenting plan, the home environment, I mean.
You're saying the multiple partners in the home?
Yes, they have come and gone.
Okay.
We are also going to be showing evidence regarding the minor child's at both attendance at school and how she is done at school. It has changed multiple times, and there was a period where the minor child was enrolled in school and then she wasn't. She was apparently attending a school, to my client's knowledge, and then that school turned out to be closed. So the minor child's educational stability is also being shown as a material change in circumstances.
Okay.
And then we are also going to be showing that my client has been denied visitation, and then also his visitation has been interfered with. So sometimes he would get his visitation, but not according to the parenting plan. Whenever he would try to contact the child, there will be issues with the contact, and we'll be showing evidence corroborating that as well. So to narrow it down, the major four are the home environment, the educational stability, the actual visitation, and then the contact and access to records. Nicole, did you have any more that you wanted to add? You looked like you were going to say something.
Only one can be one attorney per concept, so we're still in openings. Ms. Ferre, and you're saying that these things were consistent. What is your argument on those things being consistent?
Yes, Judge. So as I mentioned earlier, the parties have always been separated essentially since mom has been pregnant with the minor child. Shortly after she got pregnant, they separated. Dad was in Texas at the time. Mom moved to Georgia. And during that period of time, they were not essentially, even though they were legally married, they were not essentially together. They were not in a, I guess, in a marital relationship. Essentially, my contention is that during that period of time that they were separated, even prior to the filing of the divorce, you'll see text messages back and forth about Mr. Maynard questioning Ms. King about her moving on in a relationship. You'll also see text messages back and forth about him talking about, I won't quote no other man around my child. You'll also learn that at the time, you'll also learn that at one point in time, Ms. King, Mr. King, and Miss Melanie King, who was the third partner in their polyamorous relationship, you will learn that she was involved in the pickup and drop off and was present, and Mr. Maynard knew she was there. That was all prior to the entry of the divorce decree. And as I mentioned earlier, Mr. Maynard is the one that discussed the polyamorous relationship with my client, showed her videos, they talked about it, talked through it. You'll learn that as well. So that is not a condition that just came after August 28th of 2019. You'll also learn as far as the home environment, Ivy has a relationship with mom, certainly, and also with Mr. King. Mr. King, you'll learn, has been present in her life since she was one, so since 2018. You'll also learn that Mr. King and Miss King, my client, lived together since 2018. So this is all prior to the final entry of the divorce decree because the parties were separated. As far as the schools, Ivy is in kindergarten, Your Honor. She is in her first year in kindergarten. She's only had 2 schools of kindergarten. The first school that she went to, Your Honor will learn, was Choice Prep Academy. As I mentioned, Ivy has been doing very, very well. And so you'll learn that mom is very in tune to her educational needs. And mom has been taking that into consideration. And that's been at the forefront of how she raises Ivy and teaches her. Because she felt like Ivy needed more than what Choice Preparatory Academy could provide. Mom changed her schools this semester, and she is now at Shadow Rock Elementary School. So prior to that, Ivy was just in daycare. I think Dad's talking about daycare and not school. You'll actually see text messages from Dad where he emphasizes, why are you taking her back to the daycare? This is not school, it's daycare. So the quote, change in schools is not a change in school. Certainly there was the pandemic where there was some school closure. There was a period of time that mom had to homeschool Ivy, and it was daycare age. And then also, Your Honor, we'll learn the daycares that mom put Ivy in. But again, same situation that existed prior to the final entry of the divorce decree. We have plenty of text messages from 2018 where they discuss multiple times her daycare situation. So dad's been well aware. There has been no material change as it relates to the school or daycare. As far as the denied visitation, again, there's been no material change related to denied visitation. The parenting plan that we plan to introduce to the court, I pre-marked it as Respondents Exhibit 3. Your Honor will see on page 2 of that, that there is a provision that contemplates in the event there's any, quote, unforeseen emergency or illness to the minor child. Your Honor will learn that the instance that dad is referring to related to a COVID exposure. And so mom took measures around that as it related to the COVID exposure, and she had a full-on discussion with dad in that regard. And the provision, Your Honor will see on page 2, provides that if there has been any time missed due to unforeseen emergency or illness, that they should then discuss any makeup time. And you'll learn that those discussions did happen between my client and Mr. Maynard. So as far as any denied visitation or interference with visitation, that simply does not exist and is not true.
I'm sorry, never mind. You have one more left.
Yes. As it relates to, excuse me, as it relates to contact and access to records, you'll learn that Ms. King has always provided that with information about the minor child's daycare where she's located and school. You'll also learn that Mr. Maynard went directly to the school himself where she was located. Your Honor will also learn that, as I mentioned, Mr. Maynard has always had access to her records. He carries IEVI on his health insurance. He has primary access and information to that. He's taken her to the doctor. He has records for that. As far as the school, he has information regarding that as well. You'll also learn that one of the daycares that he complained of actually requested that dad submit and turn in his paperwork and information needed to give him any passwords, portal access, whatever they needed. You'll learn that dad simply didn't do so. And so all of this that dad complains of, he only took action through his lawyers after he filed this case. None of this happened before he filed, and it didn't exist. Excuse me, it's not an issue, number one. But to the extent that there is any complaint raised by dad, that was fully discussed prior to the entry of the divorce.
All right, thank you. You may proceed. And who's calling the first witness?
Your Honor, I will be calling the guardian ad litem, Miss Tori White.
All right, actually, Ms. White is going to be called as sports witness. Ms. White, raise your right hand. Actually, let me go ahead and ask all three of you to raise your right hand. Mr. Maynard, Ms. King, Ms. White, do you solemnly swear or affirm the testimony about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Okay. Ms. King? Unmute yourself.
I do.
All right, thank you. Place your hands down. All right, Ms. White, you can go in your narrative form. All
I
right.
appreciate, thank you, Your Honor. I appreciate
Mhm.
the opportunity to represent IEVI Maynard's best interest in this matter. As Your Honor has heard in opening statement, IEVI is 6 years old and attends Shadow Rock Elementary. She's a new student at Shadow Rock Elementary. The second semester she began. I have interviewed multiple witnesses related to the parties. Most importantly, I've interviewed maternal grandmother on behalf of petitioner father, Adrian Maynard, because there is an estrangement between the family, between respondent and her family. I've interviewed several of respondents, friends, and network in the community who support her as a parent. Your Honor has heard that the parties live a great distance apart. I have visited both homes, one in Columbus, Georgia, and one in Decatur or Stone Mountain, Your Honor. And both homes represent a comfortable environment for the child. In fact, I found at mother's home, the child's bedroom was the most comfortable of all the rooms. They were enduring some renovation,
I'm
and
sure it's the
the
most
child's
comfortable.
bedroom was
That's where all the action
light
goes.
and airy, many toys, many clothes
Mom's room's the
and
best.
developmental books, etc. At father's home, what was not mentioned in opening statement is there are 2 additional children. Father is remarried to Alessandra Maynard, and Alessandra brings into the family, a blended family, 1 son, Jaden, and they have together, the couple, the Maynards, have 1 daughter, Esme. Esme and Jaden are very bonded to this child, Ivy Maynard. There's a significant sibling bond. Ivy believes herself to be in charge of her siblings and conducts herself accordingly.
Definitely, Tommy.
How old is Esme and Jaden?
Esme, Your Honor, I believe is just 18 months under 2. Jaden is about 10. And I would have to refer to my notes to be exact, but those are approximate ages. Those children form as a unit. I would call them a hive. They are very close. They march around, change outfits, and put on costumes, and Jaden is right there with them.
Are they talking about the kids or the polyamorous people? It's got to be hard on this poor kid. They said many partners, not several. They said many partners. So that's like, it's not swingers. They're in a relationship. That ain't going down in this Jersey boy's house. I'll tell you that much. It doesn't happen in North Jersey.
Ivy has her own bedroom at Dad's house, and Esme is actually the one in charge, Judge, the little one,
Michael.
and she runs the family. And Ivy
Definitely Sparta.
subjects herself to her younger sister's control quite willingly. She's very patient with her. It is a loving relationship. It was described early on that Ivy is a smart young lady, and she is. The adjective that I would use to describe her is dynamic. She is bright and loving, and I've never visited with a child who has introduced me to her parent like I experienced at Mother's Home when she introduced me to Terrence King, who serves as a surrogate stepfather. They're not legally married, Your Honor, but he resides in the home and does conduct himself and does stepfather activities such as transportation, attending school events, helping Ivy with homework, those sorts of tasks, etc.
He's the
And
caboose.
Ivy introduced me to him. Miss Tori, this is Mr. Terrence. She is a bright one, a bright bulb, and a shining star. And I contribute that to both parents' input. I can see a little bit of both parents in Ivy's personality. Which is always, as a guardian, is nice to see a reflection of both parties in what is their product or their yield. The multiple records were reviewed as to the doctor incident. Ivy has, for all intents and purposes, I'm not using the medical term, but an additional toe or a fungus. And to control that fungus, you will hear
It's no fungus.
that the doctor recommended that Ivy wear socks. We were able to verify that information in records. And there is a dispute between the parents. Terrence King prohibits Ivy from wearing socks routinely. And that was verified through conversations with Ivy. You will hear, Your Honor, that Ivy feels split and has a loyalty bond between both parents, and that was very apparent. She has some concerns about what she shares when she's outside her mother's care, and she has some father has
We are going to see the toe. I have footage of the toe.
Before she came to my office for the first visit, instructed her that she would be seeing a guardian ad litem, et cetera. And that is what caused me to seek out a forensic interview with the child so that I was clear the information I was receiving was truly from Ivy and not from one of the parents.
Mhm.
Dr. Levy has a tremendous reputation, Judge, and Dr. Levy's representation was that she was not coached, but she was aware that she was coming to my office to speak with me. Mom made that, alerted me to the issue. I believe she had had a conversation with Ivy after an exchange. And I appreciate Mom coming forward with that information because any information I share with the judge needs to be unfiltered, obviously. As far as schools, there have been a series of schools or daycares. I think that is the confusion. She has been in multiple daycares, and there have been curriculum at those daycares. But her school has been Choice Preparatory Academy up until recently when Mother transferred her to Shadow Rock. When I asked Mother about the reason behind the transfer, she explained the curriculum was not meeting her needs. And I applaud her for making that decision early on. Again, Ivy is bright, and I would not want any curriculum deficiencies to inform her delay or a delay for Ivy's progress. You will hear that about the polyamorous relationship early on in the investigation. It was revealed to me that there were additional people in Mother's relationship. Ivy sees these people as friends of Mother. They are loving towards her and nurturing towards her. But I do have a concern about the coming and going of people. Ivy bonds quite easily to folks, and it is a concern. However, to point out and to clarify, Father was aware of the relationship prior to the entry of the divorce, the multiple partners.
How do you know that?
I've asked both parties, Your Honor. I've asked both parents, Mr. Maynard as well as Miss King, formerly Maynard.
This judge is like, what is going on?
Okay.
The household functions as a support system, a network. The various partners contribute to household duties. They do contribute to duties related to Ivy. For example, transportation to events. Ivy did not complain of any inappropriate conduct, for example, hitting, neglect, nothing untoward was relayed to me as far as Ivy is concerned. There is an issue with discipline. Father complains that Mother is overhanded or heavy-handed in her discipline, and that stepfather, Terrence King, disciplines the child with corporal punishment. Ivy shared with me that that has occurred in the past, but no longer occurs. You will hear, however, Dr. Levy shared with me that she had to speak to both parents about using corporal punishment with Ivy. Mother raises Ivy in a unique hybrid style of parenting. It's a blend of a Montessori program wherein you instill independence in the child. By way of example, she has taught Ivy to dress herself at a very young age. She is in the wash in terms of the parents judge. Both parents work outside the home as customer service agents. Father has a relationship with the military and is in the reserves. He receives a great deal of support from his new wife. The school that Ivy would attend, if Your Honor decides to change
What's up, Jen?
custody, is an excellent school. And it has a Target-like program available for Ivy. Jaden, the stepson, participates in this programming. The mother works outside the home. Oh, father works Monday through Thursday. I think it's 8 o'clock, 8:30 until 4:30. And then he leaves early on Friday afternoon, about 12 p.m. Father is Muslim and attends mosque on Friday afternoons. Mother works outside the home and has some work flexibility to work from home remotely. And her work hours are generally 9 to 6 p.m. Also as in customer service. And again, Mr. King provides supplement to the child's care, picking up, dropping off, that sort of thing on her behalf. In fact, the meeting for Dr. Levy, Mr. King transported her to that meeting. I'd like to speak just a little bit about the relationship that mother has with her family, the maternal grandmother, maternal grandfather, and the maternal aunt. It's an estranged relationship. It ebbs and flows as far as contact, but father has allowed, if you will, the word allowed, that extended family to have a relationship with the child. So that family visits Ivy in Columbus during his parenting time. And they are deeply concerned about mother and the choices that mother has made. They are deeply concerned about Ivy, and they miss their granddaughter quite appropriately. Ivy speaks very kindly and lovingly towards her maternal grandparents and maternal aunt. And again, commending father petitioner for extending himself or that time to them so that that relationship can be maintained.
Okay, do you know the nature of the estrangement, and does it, I mean, obviously, no matter what it is, it affects her ability to have, I guess, complete access to her grandparents, but do the nature of the estrangement affect you? Like, did you know why it happened and whether it is of concern?
Yes, the nodding is
It relates to
annoying.
Mr. King. Mr. King has an extensive criminal background,
Hey,
and
far in the
that
building.
background informed the maternal
Drop
grandfather
your link, K
and
far.
grandmother of Alarm. Um, they believe that he was mistreating their daughter, Ariel King, the respondent, and they were quite alarmed because of the nature of the polyamorous relationship, the coming and going of different individuals. Um, there was a threat that was made from Mr. King to the maternal grandfather of a physical nature, and that caused the initial breakdown of the relationship. Again, it's been ebbs and flows as far as contact. Ariel King will reach out to her parents from time to time, but in terms of consistency, Mr. Maynard, petitioner, has been consistent in supporting that relationship with Ivy and her maternal grandparents or maternal extended family.
Okay, all right, thank you. And your investigation involves the contact access to records.
Yes, Your Honor. You will likely, I don't know the evidence, but you will likely see text messages from Ms. King to Mr. Maynard. You will not have this information along those lines. You cannot get this information. Ms. King is somewhat guarded in the information that she shares with Mr. Maynard. She believes that he was litigating all along while seeking various information, school access, her physical address, and the child, by nature of the relationship, the child's physical address, and doctors. So there was a great deal of back and forth about give me information. No, you can't have it. Oh, here it is. Mr. Maynard, however, was able to find or source the location of the daycare, and Your Honor has that transcript where that director was deposed. There was a there was an uproar at the daycare facility. Mr. Maynard came to the facility, was unwelcomed. Miss King invited him off the property. It just was a mess. But you will also hear from Miss King that Mr. Maynard withheld his information from her. I did not see any evidence of that, but I certainly, when I interviewed Miss King, she made me aware that he at one point withheld his physical address. Again, I don't have information to verify that. But Mr. Maynard has had to work harder than he should, I would say, to gain information about the child, where she attends school, etc. Now, on this recent transfer of schools, Ms. King did an admirable job, and she alerted him to the change in school quite quickly from Choice Prep Academy.
So now this isn't any old live stream. This is time served. We don't just keep playing one old thing and listen to my stupid mouth talking. We're going to flip a little bit because I know this is getting a little long-winded. So what we're going to do is I'm going to give you a little surprise. I got a little couple clips dropped from people in my Discord and a couple ones that I found. We got people new coming in here. I love it. We have newbies, my oldies. Let's roll. Let's do a little time served intermission. Let's have some fun. Give me 1 second. Let's rock and roll. Here we go. And let's go to my girl Kate's favorite. Let's get a little taser going. How about a little taser? Let's do a little taser. Taser up! This is my favorite. All right, now we are gonna get a little. Let's do. This is a SeaTac from yesterday, and this guy is, I don't know what. Maybe my SovSits can tell me what this guy, what's this deal here. But I don't know what's going on here. We got Rehinge in the background with pictures he's showing everybody. We got just everything in this one, and then I promise we'll go back to the PolyRouple. I just needed to break that up. Let's rock and roll with this one. Enjoy.
Hi, Mr. Blau.
Hey, how are you today, Your Honor?
I'm doing well. How are you doing?
I'm doing quite well, thank you. Much better.
So have the parties having an opportunity to read the 1077 evaluation?
Yes.
Does either party take exception?
Your Honor, I'd like to make a motion.
You have an attorney who's here to make motions on your behalf.
Yeah, I don't accept him as my lawyer. I want to represent myself pro se. Under the Sixth Amendment, Powell versus Alabama in 1932 says the right to the aid of counsel is a fundamental character. This is about one's choice to counsel, and that includes myself. In Chandler versus Freytag, 1954, a defendant must be given a reasonable opportunity to employ a counsel and consult with counsel. I wasn't given the ability to really consult with my counsel whatsoever.
Would you like some time right now?
And then Feretta versus Cali, 1975 says the right to defend myself, even if it's to my own detriment, is my right.
Mr. Blau, would you like some time to talk to Mr. Ionati right now?
No, I would like to terminate him as my counsel.
Okay. You have been evaluated under the court determining your ability to proceed.
Yeah,
I have that evaluation. Please let me finish. I have that evaluation authored by, I think it was Dr. Crowley.
That's Judge Rhea Perlman.
Crowell.
Yeah, Crowell. And she's indicated that you're not able to proceed under both prongs, that you are not able to understand the nature of the proceedings against you and assist in your own defense. For those reasons.
In 1077, it says the definition of incompetency means a person lacks the capacity to understand the nature of the proceedings against him or to her, or to assist in his own defense as a result of mental illness or defect.
Right.
I do have the capacity to understand what I'm in court for, and I would argue that I am not incompetent.
And I understand that's your position, and you made that clear to Dr. Crowell as well. However, I'm adopting her opinion, but absent argument from the parties otherwise, and I don't hear that happening.
I think he's
sounds
both,
like
Hector.
Both attorneys are not contesting the finding, the opinion of the
Same
evaluator.
thing.
Is that correct?
Yeah, I have no basis to add anything to the conversation, the objection.
Is that the prosecutor Mercer talking?
That was Mr. Mercer talking, yes.
Okay, hey, prosecutor.
So I'm going to make the finding that you're not able to proceed and dismissing this case without prejudice. However, the evaluator opined that you should be evaluated by a DCR prior to release, and I'm going to follow that recommendation as well.
So
I'm denying your request to represent yourself because I have found that you are not able to proceed.
And you're going to dismiss my charges?
Correct.
Based on incompetency?
Yes.
But, Your Honor, if you dismiss these charges today on my incompetency, and I am found competent by evaluators in the next week, you may be in violation of law based on the fact that anyone can see I'm extremely competent right now. Hey, Dan Abrams, you're watching. Go to Facebook, Rehinge. I'm a person who gets laws passed.
Somebody Facebook Rehinge, please.
I know, and I read that in the evaluation. Yep. I'm adopting the opinion of a trained professional, which I am not. I rely on those employees of Western State. She has a PhD and has been doing this for a long time. And I'm relying on that opinion. This finding today.
Mr. Kendra Crowell said in this paperwork right here that you ordered me, it says I have the right to a second evaluator. And Mrs. Crowell said she could be that second evaluator when she saw me yesterday or 2 days ago. I don't understand how you're violating your own order now, because in here it says I have the right to a second evaluator.
Except that you're represented by counsel. And again, because I've made the finding that you're not able to proceed, I'm not going to allow you to represent yourself.
By counsel that never had me sign anything, never talked to me for more than 3 minutes total,
And I've just given you an opportunity to talk to him longer, and you said you didn't want to do that.
No, because he just lied to me. He said, he told me basically that he told me what was going to happen today. My understanding is that a lawyer works for me, not a lawyer. A lawyer doesn't tell me what to do. I get to tell a lawyer what to do. That's pretty basic. I mean, he's working for me. I'm not working for him, and he won't go along with my. I want to plead not guilty and ask for my Sixth Amendment right to my Sixth Amendment right. In all criminal prosecutions, you shall enjoy the right. I want the right to a speedy trial by an impartial jury of the state and district wherein the crime shall have been committed. I have the Sixth Amendment rights. This is in violation of the Constitution that you swore to uphold.
It is not a, Mr. Blau, this is the last we're going to discuss it right now, or at all, because the case is dismissed. I'm adopting the finding that you are not able to proceed under 1077, RCW 1077, and dismissing this case. The Constitution also requires that a person having been found unable to proceed shall not be prosecuted.
That's fine. I respect this is your court, not my court. I will, however, appeal this decision, and I'll take it all the way to the Washington State Supreme Court if I have to.
And that's fine. That's fine, sir.
I will have the head of the ACLU from Washington, D.C. beside me.
Okay, that's absolutely fine. I'll look forward to reading the opinion.
And by the way, this is awesome. The Ricky Garcia Act.
Okay, thank you.
Have you read
We're all
this?
done. We're all done, sir. So as soon as I'm ordering that you be held until no later than,
My counsel said 72 hours max.
it's actually 120 hours.
Judge
So I
reaffirmed.
can be held in jail for another.
March 20, no later than March 23rd at 11. It'll
March
likely be much,
23rd at
they've been
11.
moving faster than that, so it should likely be faster than that.
March 23rd.
Just so you know, Rehinge is an LLC.
At 11. So I'm being held I'm being held in a jail for another 34 days.
Until no later than. So it may be tomorrow. I don't know. It's as fast as they can do the evaluation. All right. Thank you, sir.
Thank you, Your Honor.
Pass the iPad. Next. Next up.
And then, Your Honor, you ready for Rice?
Come on.
Yeah.
I know we're going to get back to the PolyRouple, but come on.
Your Honor, just so the court's aware before you call this case, this is Patricia Rice.
Ms. Rice.
So I think it's filed under Patrick J. Rice. Ms. Rice prefers to identify as Miss Patricia Rice. She said that's her legal name. I couldn't find a docket entry for that name. I didn't see that it was an AKA, but Ms. Rice indicated she had other history under the name Patricia Rice, but I didn't locate it.
Okay. So what are we doing today?
Ms. Rice indicated that she had just been evaluated and found not competent. Based on the mix of information that I was given, I did have some competency concerns, so we are also asking this court to have her evaluated under 1077.
Does the city have any objection?
No, to the competency evaluation, I don't. I would ask that it be done in custody. This was a situation where I think February 3rd, at least our notes, I asked for bail on each of these, given no lack of or no ties to the community and an extensive out-of-state history, which should have been provided to the court, 51 pages. And we had a immediate failure to appear with notice in hand after the release in early February.
I was in King County Jail during that time. When they released me from here, they released me directly into King County Jail, and I've been in King County Jail all the way up until yesterday.
What were you held on, ma'am?
I was held for felony harassment. The police department was, trying to say that I was harassing somebody when I was sleeping in the parking lot. I was actually cleaning up the parking lot. I was pepper sprayed. I was beat up by the police. I had it all on like I had everything, like evaluating everything that I was never actually released.
Do you recall what name you were booked under? Were you booked as Patricia?
No, I was booked under Patrick Joseph Rice.
There is
Patricia.
a booking on the 13th of February, so that would have been about a week after he was released here.
That's correct.
He
That's
was
the one I was
out the 14th of
Exactly,
March.
David.
So that
and that's where they did the competency hearing and said I was uncompetent for trial.
that's a Seattle Municipal Court case as well from the previous one. So I this is all new information to me, so I would need a second.
Yeah, I'm looking too.
So what I'm gonna do is Credence and Bishop is starting in 3 minutes. What I'm gonna do is edit it and compact down for part 2 of the PolyRouple. Right after Credence and Bishop, I am gonna go back on and we're gonna play the conclusion of the PolyRouple. All right, you're gonna get the toe, we're gonna get dad talking, and we're gonna get when there's the day 2 coming, and it's in the very near future. So, like I said, this is part of the power back to back. We are the PolyRouple of LawTube at this point. You just watched Time Served, and now hop on to Credence and Bishop at 1 o'clock. I'll be in the room. I'll be hanging out. Guys, see you later. I will see you at 2 p.m. today for the stunning conclusion of day 1 of the PolyRouple, where we get to see the toe/fungus. All right, guys, I will see you back in 1 hour. Go enjoy Credence and Bishop, baby.